Hyderabad and working as a legal associate in Thukral Law Associates. So the topic on which we are discussing upon is the amendment in the Arbitration and the Conciliation Act of 2019. The Arbitration and Conciliation Amendment Act of 2019 as a bill was passed by the lower house of the Parliament, Lok Sabha, on 1st August 2019 and passed by the upper house of the Parliament, Rajya Sabha, on 18th July 2019. Soon after 9th August 2019, the 2019 Amendment Act received the assent of the President and was published as an Act number 33 of 2019. Thereafter, certain sections of the 2019 Amendment Act were notified on 30 August 2019. The 2019 Amendment Act has been one of the most awaited and commended legislation amendments in recent times, dividing the opinions alike since it was first tabled in Lok Sabha on 10th August 2018. However, its passing was delayed due to the lapse of the 16th session of the Lok Sabha. The 2019 Amendment Act encapsulates various recommendations made by the high-level committee, which is also named as the B.N. Krishna Committee, chaired by B.N. Krishna, retired Judge Supreme Court of India, which submitted its report on 30th July 2017. The committee was constituted by the central government in order to eliminate some of the challenges and difficulties with respect to the Arbitration and Conciliation Amendment Act of 2015 and rationalize the arbitration institutions via the ad hoc arbitrations. The 2019 Amendment Act further addresses measures to make the arbitration procedure most robust and friendly, with a clear emphasis to address the ease of doing business, ranking as well as making India a hub for international commercial arbitration. The 2019 Amendment Act also aims on streamlining and encouraging the institutional arbitration by establishing an independent body and also a body corporate promoting ADR in India. The key highlights of this act is the 2019 Amendment Act has brought into some significant changes, including appointment of arbitrators by the arbitration institutions instead of the courts in India, setting up of the Arbitration Council of India, introducing timeline limits of 6 months for filing the pleadings, making international arbitration beyond the purview of the 12 months adjudication period prescribed under Section 29 and altering the scope of Section 17, Section 45, Section 50 of the Arbitration Act, and lastly introducing Section 87 to clarify the prospective effect of the 2015 Amendment Act, despite the comments of the Honorable Supreme Court in the Board of Cricket Control in India versus Cochin Cricket Private Limited and others. But still the question remains the same. The proposed Section 87 Clause B is in conflict with the recent judgment of the Honorable Supreme Court in the BCCI judgment, wherein the Supreme Court has held that the 2015 Amendment Act will apply to the application which are pending in various courts for challenging the award and were filed before the commencement of the 2015 Amendment Act. The 2019 Amendment Act is definitely a step forward in promoting the institutional arbitration in India, along with streamlining and overcoming some of the challenges faced after the enactment of the 2015 Amendment Act. The 2019 Amendment Act take place the arbitration practice and laws into a new domain with a substantial safeguard and regulation to further plug the holes, to robust and sustainable mechanism to support the growth of the arbitration in India. The 2019 Amendment Act, however, did not take into consideration some recommendation by the committee, notably on incorporating the International Bar Association rules on evidence. Further, how the amendments are actually implemented would be the key to gauge in success is in future. The scope, composition, functioning of the ACI remains to be seen and implementation thereof in practice. The actual manner of implementation of the ACI would determine if it becomes a deemed regulator of arbitration institution in India, of sorts or facilities, a mushrooming of the arbitration. Institutions in all those states in India which do not have the same at the moment and promote it as a whole. These will only be clarified on the notifications of provisions pertaining to the same. We look forward to the recent amendments and what will be the key factors. That was all from my side today regarding the arbitration and its recent amendment. If you would like more information, you can find our contact in the description of the video. Check out more videos from my YouTube channel and see you next time.